Hey, good afternoon, everyone. My name is Tyler Raquette from Mosaic Compliance Services. I'm the president and CEO of Mosaic, and I'd like to say thank you to all of you for attending today. As many of you, I'm sure, are already aware, last Friday, the FTC announced that they had sent letters to 97 dealership groups across the country, uh, stressing the need for truthful and transparent pricing and warning them about deceptive pricing practices. So to tackle that, we have Jim Ganther here today, the CEO and founder of Mosaic Compliance Services, and going on 30-year automotive industry veteran. We're going to be very conscious of your time today. We know everyone is busy. We think this presentation should take about 25 to 30 minutes, and then we'll be happy to answer questions for the remainder of the hour. Please feel free to use the Q&A feature inside the Teams meeting, and we'll get to all of your questions once Jim's done going through his presentation. With that, I'm going to hand it over to Jim and let him give you all of his disclaimers and any other introduction he'd like to. Take it away, Jim.
Thank you very much, Tyler. Yes, we do have to have a disclaimer, and it is this. The information we're sharing today is provided for general educational and informational purposes only. It is not legal advice, and it should not be relied upon as a substitute for advice from qualified legal counsel regarding your specific situation. In other words, although I am a lawyer, I am not your lawyer. If I were your lawyer, I would have charged admission. Let's jump in. What's at stake here? Well, last Friday, just 5 days ago, 97 dealer groups, not 97 dealer locations, 97 dealer groups received FTC warning letters. And even assuming an average group size of only 10 or 12, that represents about 1,000 dealership locations were put on notice that their advertising practices might be defective. This is against a backdrop of very recent activity by the FTC that included a $20 million fine against Leader Auto Group. That is the largest monetary fine ever against a dealer group by the Federal Trade Commission. Also in the past year, the FTC alleged that the three location Lindsay Automotive Group had overcharged 88% of its customers. And getting back to the Leader case, the FTC has alleged that 80% of their customers were charged for voluntary protection products, or what the FTC likes to call add-ons, without customer consent or knowledge. And this is the timeline. You will notice something. It is recent. Asbury Automotive got hit in August of 2024, less than 2 years ago. They were alleged to have deceived their customers with respect to voluntary protection products being added without their knowledge. And there's also a racial discrimination charge for adverse impact. That, however, has been dropped, but the deceptive trade practice allegations continue. Then in December of 2024, Leader Automotive was hit with what became a $20 million settlement for deceptive trade practices. That did include advertising. And in that same month, Lindsay Automotive got hit. And in that case, like the Leader case, individual executives were brought in for personal liability. And one got the sense that those cases were hurried before the change of administrations. Asbury, Leader, and Lindsay all happened under the Biden administration before the Trump-Vance administration went into place in January of 2025. But the 97 letters that went out last week, this is an initiative under the Trump-Vance FTC. So the foot has not come off the gas at all. And in fact, I believe that what could result from what we saw last week might be the largest enforcement activity ever against the retail automotive industry in the United States. This is the template of the letter itself. let's focus on the 6 bullet points that start at the bottom of page 1 and continue on the top of page 2. These are the specific allegations. That these 97 groups were advertising a price that does not reflect all required fees. They were advertising a price that reflects rebates or discounts not available to all customers. They advertised a price that fails to take into account the amount of an additional required down payment. Conditioning the advertised price on consumers using dealer financing. Requiring consumers to buy additional items not reflected in the advertised price, and advertising unavailable or non-existent vehicles. What did it say? What did it mean? Well, it says that your advertised prices may be lower than what you actually charge, meaning you are now on documented notice. Future violations will therefore be considered willful. It is absolutely true that the 97 dealer groups and the constituent locations, they're on actual notice. But I would argue that the entire industry is now on constructive notice because this news is spreading through our industry like wildfire. There are multiple webinars just like this one from my competitors that are saying the same thing. It will be very difficult for a dealer to say in a week, we didn't know. The letter says advertised prices must include all required fees. Well, the FTC already has data on their advertising before they wrote that letter, and you're not including all of your fees. The FTC said it will monitor the marketplace, and I'm using air quotes here, take additional action as warranted. Well, what additional action means is not more nasty letters. It means enforcement. This was a shot across the bow, not a torpedo into the hull. You may thank the FTC that they didn't go after these 97 dealer groups firing for effect. They essentially, they're giving these 97 groups, and by extension, the entire industry, fair warning. But I'm telling you, it's the last warning we're going to get. The next thing we're going to see will be actual enforcement actions. Similar letters being sent to other auto dealers. Well, look, 97 groups constitutes over 1,000 dealership locations. This is the broadest warning I have ever seen. Let's take a look one by one at the 6 specific sins the FTC identified. The first was hidden fees in advertised prices. The FTC is requiring advertised prices to include every mandatory fee any customer must pay. The only thing you're allowed to exclude are government taxes and registration. Let's stop here for a moment. All across the country, for decades, dealers have been advertising prices that have excluded things like dealer fee, dock fee, destination fee, and other fees. Those fees generally were discernible from an ad that in the footnotes, maybe you call it fine print, but within the 4 corners of an ad, all of the elements of the advertised price were included. Nothing typically was excluded or totally hidden, but it wasn't all pulled into the big number on the top, total selling price, for example. Well, when the vehicle sales rule was proposed, what also known as the CARS rule, the vehicle sales rule formally defined you have to put all of the advertised elements of a price into the total selling price. The vehicle sales rule was overturned by the Fifth Circuit Court of Appeals over a year ago, but it still exists in the California CARS Act. And now, what the Federal Trade Commission is saying is they interpret the advertised price to mean what was formally defined in the vehicle sales rule as the total price. So, however we interpreted it, and the interpretation was reasonable because the FTC hasn't been enforcing the way dealers have been doing business for decades. Now we're all on notice that they're changing their interpretation and they're going to be more aggressively enforcing total sales price. You cannot exclude dock fees. You cannot exclude dealer fees. You cannot exclude destination fees. You cannot exclude mandatory prepackaged, pre-installed products. You can still do those things, but they must be included in the advertised price. Rebate stacking, again, easy to detect. You cannot include, or rather, I should say, deduct a rebate from your advertised price unless it's a rebate that absolutely everybody qualifies for. If you have a Lexus December to Remember and everyone gets $1,000 off, if it's Toyotathon and everybody gets $1,000 off, you can reduce your advertised price by that amount. But you cannot take out of that first-time buyer rebate because not everybody is a first-time buyer. And for heaven's sake, don't stack rebates. You cannot deduct from your price a first-time buyer rebate and a repeat buyer loyalty rebate. They're mutually exclusive. The only rebates you can take out are the ones that are absolutely applicable to everyone. Down payments, undisclosed required down payments. We're talking here about an ad that has a really attractive price. The advertised price, the total sale price is very attractive. But then in the fine print, it will say, assumes $10,000 cash down payment or trade equity. Can't play that game ever again. If that's your math, it won't work. You cannot deduct from your advertised price an assumed down payment or trade equity. Neither can you say that this is conditioned upon using dealer arranged financing. In the Lindsay case specifically, the dealers received what the FTC called kickbacks from finance companies. We don't call those kickbacks. We call those dealer reserve or participation. Nothing illegal about that. But what is illegal is conditioning a particular price on a particular financing program that the dealer chooses, which presumably allows them to have the highest dealer reserve. And of course, if someone comes in with a check, either from their personal checking account or from the local credit union, dealer will get zero participation in that deal. Well, you can't condition your sale price on dealer financing. Unauthorized add-ons. I don't really like that term. They're vehicle protection products, but this is what the FTC is calling them, somehow suggesting that they're really fluff and don't have actual value. Well, 75% of Asbury's, this is alleged by the FTC, 75% of their customers were charged for add-ons they didn't authorize or weren't told or were told were required. In the Leader case, 80% of those customers were charged for at least one unauthorized add-on. The profit margins called out in the complaint were alleged to be over 99%. I don't find that offensive. A 100% markup for many products is entirely appropriate and what the market will bear. I mention it here because the FTC is acting as if profits and what I would consider reasonable profit margins are unreasonable or somehow deceptive. They're not. There's nothing wrong with a 100% markup on a particular vehicle service contract because, amongst other things, you want to retain profit and there's still commission being paid on that to the F&I manager. In the Lindsay case, 68% of the consumers were charged for add-ons without consent, or they were falsely told they were mandatory. All of these actions, all of these practices are absolutely unacceptable from this day forward and probably in the past. And then the sixth allegation was phantom inventory and fake reviews. The phantom inventory is advertising unavailable vehicles. There's certain things you can't change. If you put out a newspaper ad advertising a specific vehicle, as soon as that vehicle is sold, you can't go back and change a newspaper ad. However, on your website, you should delete that particular vehicle as soon as possible after it is actually sold. But the bigger problem is advertising vehicles that you don't have at the time the ad was placed. When you do that, it looks a lot like bait and switch. And the bonus was the fake online reviews. We see this in the Leader case, where it was alleged that employees were either required to post fake reviews or they were threatened if they did not. They were alleged to have been paying bonuses for generating fake five-star reviews. And managers suggested that employees use family members for instant volume. And in one case, it's alleged that they refused to give a customer her car keys until she posted a positive review. That is absolutely verboten. Has anyone at your store ever been asked to post a review as part of the job description? The answer is yes. You better stop it because we're on notice. The FTC is watching. How does the FTC investigate? These allegations to those 97 dealer groups all had one thing in common, and that was advertising, and specifically web-based advertising. Think about it. Advertising violations are violations that you advertise. They are easy to detect, but that is not the only method. The FTC will actually survey customers, especially if they've been getting complaints with respect to a particular dealership or dealership group. That's where we got these 75 to 88% statistics. Investigators will contact your customers without your knowledge. They will have the ability to look at your transaction data. If you ever receive a subpoena, which in this context is called a CID, civil investigative demand, they can get into your DMS and everything is in there, including the price paid for a vehicle, which can be compared to the screen caps they took of the price advertised, which leads us to advertising screen captures. They can go not just to your website, but to cars.com or AutoTrader or social media and download, capture the ads, and then later compare them to your actual sales practices and the data that's contained in the DMS. They also have investigative rights to look at your internal communications, and some of these can be quite damning. We never deliver near the stated price. They're not leaving without buying. Those were actual quotes from internal emails in the Leader case. People will use internal emails or text messages and their guard will be down and they may say things that are inappropriate. They look terrible when you get them in front of a judge or a jury. And one other thing that we're seeing more commonly now is individual liability. Owners, chief operating officers, general managers have been personally named, and it's not an accident. They are literally going after humans, not just corporations, and we'll see how big that can become. That's personal liability, not a side issue. It is a strategy. If you're a general manager and you want to increase your profit margins, you might engage in deceptive advertising practices. But if you know that you will be personally held liable, it is likely that you will tap the brakes, think about it carefully, and not take that action. In the Lindsay case, the owner, Michael Lindsay, was personally named. The chief operating officer, John Smallwood, personally named, and the general manager, Paul Smith, personally named. In the Leader automotive case, that one was interesting. There was a $20 million fine levied against the corporation, but it was a Canadian corporation, and they were willing to pay it. They were a publicly traded company in Canada. They needed to make this go away. But if they had wanted to fight it, they might have succeeded because they were not subject to American law, or that would be their argument. However, Jimmy Duvas was the vice president in the Chicago area, and he is an American citizen, and he got named personally, not for $20 million, for a whopping $216 million. And yes, the exclamation point I added. He moved to have that level of enforcement dismissed. And just this year, a few months, it was denied. So he is still in the middle of this car wash with a potential liability of $216 million. The FTC wants to get your attention. And if $216 million doesn't get your attention, you're not paying it. And in the Asbury case, the general manager, Ali Benley, was personally named. These are not one-offs. You must assume this is going to be a trend, and it's going to be a trend with some really big numbers. Act accordingly. What's your compliance checklist? Well, here are a few key things to take a look at right away. With respect to advertising and pricing, you must make sure your advertised price includes all mandatory fees. This is easy to confirm. Look at your website, look at your print ads. Do you have a footnote for document fee, dealer fee, destination charges? If you have those identified, they need to be included in your advertised price. And once they're included in your advertised price, you don't need them in a footnote, do you? You can get rid of the fine print. When we see fine print, we assume you're not complying with these current standards. You must have no stacked rebates used to reach your headline price. And live inventory only. Don't advertise vehicles known to be sold at the time of the ad or known to not exist at the time of the ad. When you do that, it looks like bait and switch. When it comes to F&I products, voluntary protection products, make sure it is abundantly clear and in fact true that all voluntary protection products are optional and individually consented to. Make sure if you're using an electronic contracting platform, electronic signing, that you see the full document. The customer must be able to see the terms and conditions for which he is signing, and make sure that no vehicle voluntary protection product is ever represented as being required to either buy the vehicle or to obtain financing. Speaking of which, with respect to financing, you have to advertise the same price available to cash and outside finance buyers. There are lots of problems with having multiple costs based on how you finance the vehicle. We have a separate webinar for that. But trust me, it's a bad look and it will get you in trouble. Cash price is cash price, however it is paid. You cannot steer consumers from their pre-approved financing. If they come in and they have a pre-approved 5.9, you can't steer them to a 6.8. And absolutely do not have the disclaimer or the practice that no financing required, that financing is required for advertised price. Can't have it. Low-hanging fruit, easy to detect, easy to prosecute. And reviews and fair lending, make sure that internally, no employee is incentivized to post a review even if that employee bought a car and had a great experience. You cannot pressure or incentivize your employees to post reviews, certainly not fake ones. Make sure your voluntary protection product pricing is standardized and not at salesperson or F&I manager discretion. When you charge different people different prices for the same product, it invites claims of discrimination. Finally, transaction data should be reviewed periodically for pricing disparities. Don't assume things are being done correctly. Look, or have a third party audit it for you. Common questions we're hearing from dealers. We didn't receive one of these letters, so we're fine. Do not assume that. We believe that the FTC has identified other dealers, and frankly, we at Mosaic have been looking at random dealership websites that weren't part of the 97 dealership groups that were identified, and we're seeing the same problems. If we can find it, the FTC can find it. Don't think your manufacturer is going to get you off the hook or your co-op advertising. You, the dealer, are responsible for your ads, and so are your executives. Personal liability is a real thing, and we're going to see more of it. I've heard, oh, we've already got a compliance program. Well, that's great. You should have a compliance program, but make sure it's covering your advertising. And most compliance programs that I have reviewed at dealership locations aren't paying attention to their ads. They're not paying attention to their websites. And I've heard this too. We're just a single point store. We're too small. We're under the radar. I don't know that to be true. I don't know all 97 of the dealer groups that were hit by the FTC letter last week. But I do know that Lindsay, separate from that, was only a 3 rooftop group, and they got hit. And I've seen single points get hit. Don't assume that because you're small, you will be exempt. You're not. Okay, where to find help? We have been talking today primarily about advertising. We've been talking about the 6 points that the FTC brought up in their recent letters that we call the shot across the bow. There's more even to advertising than just those 6 points, but those are very high level points that need to be taken care of immediately. We can dive a whole lot deeper, but you got to take care of those first 6 right now, not October 10th or October 1st when the California Cars Act goes into effect. Now, why is it important now? We don't know how long the FTC is going to give the automotive industry to clean up its act. I think it is reasonable to believe that they issued these possibly impacting 1,000 dealership location letters last week and are giving us some amount of time to get educated and to get fixed. There are a lot of the webinars like this going on right now this week. 2 of our competitors have them going on tomorrow. One of my competitors has one going on right now against this one. I think we're going to get a couple of weeks, maybe, and that's all we can count on. Who's going to help you straighten up and fly right? Who can help you get your advertising corrected on a defensible keel and be a third party disinterested to help you do it? Well, in alphabetical order, non-alphabetical order, NADA. I would be remiss if I did not give a hat tip to the National Automobile Dealers Association. They have been on top of this issue for at least a decade. This particular guide, the Driven Dealer Management Guide for Federal Advertising Requirements, was published in 2017, and it is still good information. I would advise you go to nada.org and download it. That's how I got it. Good information. The prices may seem unrealistically small in their examples, but it is good stuff. I've been informed that NADA is in the process of updating this guide, but until the new one comes out, this is a really good place to start, and I thank NADA for protecting its members by publishing it. And then, how about Automotive Compliance Education, or ACE? That's their URL. They're a education and certification outfit. There's Comply Auto. They are one of our competitors. Informative, another one of our competitors. Tom Klein. Tom is an individual consultant, and he does advertising reviews and does a very good one. His particular spin on the topic is he is an expert on dealership insurance issues and can help leverage cures, fixes in your advertising program to help drive down your insurance premiums. KPA. And finally, Last alphabetically is Mosaic Compliance Services, which is my company. These are mostly my competitors. My point is this: it doesn't matter to me who you use. It matters to me that you use someone. This is not something you should rely on your own good sense to help you with. Contact an expert. Contact several. Price shop. That's great. I'm not here to plug any particular vendor, not even Mosaic. I'm just here to plug. There's an industry out there that helps you come into compliance, and you should engage with it. And with that, Tyler promised I would finish in 30 minutes or less, and that took 29. So I'm going to take a sip of water and hand it back to Tyler to field any questions.
Thanks, Jim. Surprised that you were able to get that in under 30.
I
Just
just
so
eliminated my periods and most of the commas.
Great. Just so everyone knows, we do see your comments in the chat and the Q&A, so I will get to both of those. Jim, we do have a pretty good number of comments here, so obviously try to answer to the best of your ability, but also try to get through them so we can try to get to everyone's concerns. First, we have what is the best way for dealerships to advertise optional vehicle add-ons? And as a follow-up to that particular question with voluntary protection product pricing, are you saying there should be no negotiation on the final VPP pricing, or should the initial offer be consistent?
Let me answer the first question first. How do you advertise voluntary protection products? The thing we're concerned about here is the advertised price of the vehicle, that you can walk in with a checkbook and buy that car for that price with nothing additional other than government fees and taxes. Once you've done that, there's really no limit on how you advertise voluntary protection products, provided they're fair and accurate. With the second question, there are different ways to skin this cat when it comes to voluntary protection products. NADA has proposed a policy where everybody pays the same price, unless certain non-discriminatory criteria are met, and then you document it. That is probably the safest approach. I will certainly give them credit for that. We advise that you have a little bit of play in the joints to negotiate, but that everybody's price, the price you see on the menu, everybody sees the same price first. And if you negotiate, you keep it within a defined narrow range that you never exceed. And if you just never do it. And if you do that, you can fight off the discrimination claims, because yes, there does need to be some play in the joints to be able to structure a deal that will work for the customer, but do try to keep those product price ranges narrow and reasonable. And you could possibly give additional discount percentage if people buy multiple products. However, and this is very important, make sure you have a written policy in place that says what are your parameters for negotiation, and stick to that policy.
Great. So yeah, so start at the same point and have it documented with policies in the store. Tony D, thanks for all the questions, Tony. First, wanted you to expand on the constructive notice from early on in the presentation. You mentioned constructive notice.
Okay. Constructive notice is the legal fiction that you actually knew because you should have. And there is ignorance, as they say, is no excuse. But because this has been getting so much attention so quickly, it's going to be talked about in 20 groups. It's going to be talked about at happy hour. It is fair to say that the dealership community is on notice of the FTC's new position on these advertising issues. So 97 dealer groups have actual written notice, but the rest of the industry has constructive notice. And it is enough, because the FTC doesn't have to give any notice.
What about another from Tony? Is having a price listed on the dealership website considered advertised?
Yes.
Tony's saying that a lot of dealers argue that if the inventory is priced, it's not that it's not advertised?
They would be wrong.
Okay.
It's an ad. I mean, you're offering something for sale at a price. That is an advertisement. Full stop. And if you want to continue with that definition or that understanding, you're going to be the dealer that's going to get hit with live ammo. Last week, the FTC was firing blanks. Next one's going to be live rounds. Don't be that dealer.
Question that's come up a couple of times. First from Kate, really good question here. What about advertising a payment that's from the factory? For example, specifically on leases, right? Where you have a lease GM financial incentive program and it's a factory program with certain cash down amounts coming straight from the OEMs.
As long as it's fair and accurate, that that it's coming from the OEM doesn't make it good, bad, or indifferent. Is it accurate? And if the numbers that you are advertising that came from the OEM are accurate, then you're good. Where you're going to get in trouble is you have an OEM lease program and you increase a cost, like a delivery charge, amount due at delivery or signing, thus making the OEM advertised price inaccurate. That would be on you.
So one thing you didn't touch on the presentation, and this question is addressing it specifically, what we've seen in the market so far. How do dealerships remain competitive if not all dealerships in market comply with an all-in advertised price? Will this turn into dealerships reporting their competitors?
Yes, it already has. We've seen this in the last 24 hours. Dealer groups saying we are going to stop dealer fee, doc fee. We're just going to advertise our actual price and we're going to rat out all of our competitors that aren't doing it. Historically, it has always been strange to me that advertising total price was designed to penalize the dealerships that do it right or that do it in the most clear fashion, which is advertise your total cost. And I've had a dealer who is one of the most ethical guys I've ever met in this industry said we would advertise, we'd get rid of dealer fee, doc fee. We'd bury it in our advertised price. But if we're the only dealership in our market that does that, no one will ever come to our store. I think that's part of what's going on here. The FTC is saying, can't be, we're not going to penalize the good guys. We're going to penalize the bad guys starting very, very soon. And yes, dealers will rat out their competitors, and I think the FTC will take that phone call.
Yeah, we won't name the groups or the organizations we've seen saying this in the last 24 hours, but we have seen advocacy groups and dealer associations saying that their members will be complying and reporting bad actors.
Yeah, there's a certain antitrust gloss on this. We live in Tampa Bay. There's a Tampa Bay Auto Dealers Association. I could envision the members of the Tampa Bay Auto Dealers Association getting together and agreeing, okay, starting Monday, no dealer fee, no doc fee. We all toe the line. That would be great, except it'll also be seen as price fixing, which is a little weird. So I think you're going to be making these decisions individually on a dealer by dealer, group by group basis, but they need to be made.
Couple of questions about advertising save up to X amount, right? Save up to $10,000 or advertising savings amount that includes all available rebates.
Oh,
How do you interpret that?
all available rebates is the dealership clairvoyant? I mean, the dealership does not know which rebates a particular customer will qualify for. But when you see all available rebates, it signals to me they're probably deducting all possible rebates out of the advertised price, and that is unambiguously not allowed. You got to rethink how you write your ads. No question.
Okay. Do you have to advertise optional VPP products on your website?
No. Is there anything more to that question?
No, that was it. Here's an interesting piece of rumor from the rumor mill. From Jeremy, we've heard NADA is meeting with the FTC this week or next week regarding dock fees. And while we wait for this meeting to happen, is it okay to keep the dock fee out of the advertised price and
No,
add on along with government fees? Have you heard
nope,
this as well?
I haven't heard that rumor. Um, haven't heard that rumor, and I have been. I mean, Tyler and I were up at NADA last Thursday, and I've been communicating with NADA since on this topic. So I have not heard that rumor. But there is no ambiguity here. You cannot not include your dealer fee in advertised price. There's no grace period. There's absolutely no ambiguity in what the FTC put out last week. If you have any charges other than taxes and actual government fees, they have to be in your advertised price. Now, that's it. If you can do what you want, but you might get prosecuted for it. And when I take a look at those individual liability numbers, if I were a GM, I wouldn't let it happen to me.
Yeah, and I just to add real quick, I think it's very reasonable to expect that there will be conversations between advocacy groups and the FTC moving forward. And I think it's more important than ever to stay with your ear close to the ground and stay in tune with how this all develops. But for right now, your best practice is to include all fees in your advertised price until a time where you hear differently.
And I would advertise the fact that this advertised price includes no hidden charge. There are no other charges, no hidden charges, and highlight to your competitors. Our price is the real price. Are theirs? There's a little bit of consumer education that could happen. This could be an opportunity for that. And when Tyler mentioned advocacy groups trying to get the ear of the Federal Trade Commission, that is absolutely true. But it's advocacy groups on both sides. You'll have NADA, NIADA trying to get a little bit of leniency, and you'll have consumer lawyers advocacy groups arguing the opposite. So advocacy pulls from both directions.
We've got good. We've still got 18 minutes here, and we have more and more questions pouring in. So, guys, I'm going to continue to go in order here rather than try to combine questions together. So, FTC does not allow vehicles to be advertised that have been sold because they are not ready. What if the vehicle is in transit to the dealership? Can it be posted on our website if it is not on site?
That's an interesting question. I'll be blunt, I don't know. And that's the first time I've heard that question. I don't know why you would be advertising. Websites tend to be dynamic. I mean, they are dynamic, such that as soon as a vehicle is out of recon or out of prep, you can pop it up on your website. Um, news print ads might be different. So if you expect that a vehicle will be here on Saturday and you have to have the copy at the newspaper on Wednesday, I could make an argument for that, but not on the website. The website's dynamic. You don't have to put a vehicle on there that you know is not available. And in that particular medium, I would not.
Okay. How about with third-party lead providers? If they send you a lead from an ad price that doesn't exist, is the dealer liable for false advertising, or would liability fall to the third-party company who sent them the lead?
I am not sure I understand that
I,
question.
I think the question is if you get a third-party lead, one of the third-party vendors, car gurus, let's say, and
Right.
the price that the lead is generated from is different than the price that you have advertised at the dealership, and now the customer has a different price than what they were advertised on a third-party site. How Where's that liability going to fall?
Well, it depends. And here's what it depends upon. Where did the third party lead generator get that number, get that advertised price? If they got the advertised price from the dealer, of course the dealer is going to be liable, not the third party provider or vendor. If, on the other hand, the vendor screwed up, the vendor put a deceptive price in, then they would be liable, but they're not likely the ones to be sued. Tactically speaking, what's going to happen is the dealer will get sued and have the opportunity to bring the third party in, bring him into the lawsuit for contribution.
Michael with an awesome question here, which I wish
Hello,
we had an answer
Michael.
to.
This
Is
is
there a
class,
reason?
right?
Is there a reason that the FTC doesn't approach the OEMs for their unrealistic ads, especially when every dealership in a particular market does not have one of those qualifying vehicles? I wish we could get into their heads, Michael. I don't know what Jim's answer is to this.
Um, if it's an OEM, I'm trying to think about what do I actually see on TV. If it's an OEM ad that's advertising, the new Ford 150, that's different from saying the new Ford 150 that is available at a particular price at a particular dealership. So I don't know where the OEM ads are going to fall in this. All I know for certain is that's not what was being hit in last week's letter. We keep calling it a shot across the bow. It was very broad in its application. I might say narrow in its application, but deep. And that is where I'm going to be concerned first is if I were a dealer, I would be concerned about the items that the FTC identified in last Friday's letter. Was Friday the 13th somehow, a sinister warning or just a coincidence? But the Friday the 13th letter identified specific things, and those are the things I'd worry about first, and they're all within the dealership's control, not the OEM's.
Awesome. A couple questions from Frankie here. If a consumer walks in on an ad price, do they have to be given that ad price?
They could be given a price that is lower.
They can't be
But
higher.
can't be higher. That's
And
what we're
then
talking about here.
back to the lease offer. A lot of questions about leases here. So on a lease offer, is it okay to exclude tax and fees the same way a manufacturer does, as long as it is fair and consistent?
You don't have to include taxes and fees, provided they are government fees. So sale, financed, or lease doesn't matter, just so long as there are no additional fees that are from the dealer as opposed to the government. And leasing is a little bit different because we're not selling something. You never see you can lease this car for $58,000. You buy a car for $58,000. You lease it based on math that would confuse the average consumer.
What if we run an ad in print or on TV with a price that includes a dealer discount that anyone can claim, but that discount is only available on that specific stock number? Is that still acceptable, or does the discount have to apply to all similar models?
If no, if the ad is for a specific stock number, that's fine. But if you say this price for a Ford F-150, hundreds in stock, then you're going to have a problem.
Yeah. We got something from our friend Tom Klein. Jim, I
Hello,
had an
Tom.
understanding, which may or may not be accurate, that in Tennessee it is against state law to include the dock fee as part of the advertised price. If this is true, follow the federal law and not the state law? Tom asks.
In that case, the federal law and the state law are the same. And same thing with California. California Cars Act defines what the total price is.
Jim, this is
And it
saying
is
in
this.
Tennessee it is against the state law to include the dock fee as part of the advertised
Oh, I'm
price.
sorry. I thought you said exactly the opposite.
Sorry, I might have misspoke.
In
Go ahead.
in Tennessee, you can't. Well, the point being, and this is where my head is beginning to spin. Dock fee is going to disappear. It's not that it's going to be included in an advertised price. Dock fee is a way that, yes, there are costs that dealers incur. There are overhead charges dealers incur in any vehicle transaction, and you try to recover that through a dock fee. But it's also protecting front end gross. And if you're going to charge that fee, it has to be in the advertised price. This is where I don't think it's going to actually impact Tennessee at all. because you're not going to include it and then deduct it out on your installment sale contract or your buyer's order. If you're The whole point of the dealer fee, or call it a doc fee, the whole point is that you can add it at the end. So if it has to be included in the price, if you had it in the risk, you then have to zero it out, and that's silly. The solution here is you're not going to have a dealer fee. You're not going to have a doc fee. And if you don't, then the Tennessee law doesn't come into play.
Okay, jumping over to the chat here, we do have some more questions. Start at the bottom here. What if you have a product you always put on first pencil, but it's something we can and will take off if the customer doesn't want it? Does that need to be included in the advertised price?
Yep, that is exactly what the FTC is talking about.
Okay, there we go. Good example. Let's see. From Kevin, I know advertising a finance discount isn't allowed, but are you still able to negotiate to have someone finance for a better deal?
Yeah, you're still allowed to negotiate. But remember, what we're talking about is its impact on the advertised price. If you can get the advertised price, no matter how you finance, then you're going to be okay on that specific issue. But yes, you can compete for financing, certainly. You just can't raise the cost or raise the advertised price if you don't get the financing.
So just to be, okay, a different question here, asking just to be clear, you cannot say 51,000 plus TTNL and dealer installed accessories, correct?
Absolutely not. That is exactly what they're talking about. If there are dealer installed accessories, it must be in the advertised price. And it's going to be in line one if they're truly hard ads. If you put on a bed liner and a winch on your pickup truck that you're selling, by all means, add it to your price, but you can't add it later.
Jim, Justin has a follow-up to 2 questions ago when we asked about something that can go on the first pencil but can come off. Just that if it's not required, then how is this different from any other VPP product in the F&I office?
You're not in the F&I office. This is first pencil. Let me qualify this. I get this question with some frequency. I've gotten it in the last week. When you put a product in the first pencil, you are asking for trouble. It looks like payment packing. It is this presumed close. It is a true statement that the FTC's letter didn't address first pencil. It addressed products people are forced to buy. When you put it in the first pencil, you're making it look exactly like that. You have to buy this. And now you're on defense. Now you're saying, no, no, no. We told them it's optional. You don't have to do it. Well, if that's the case, why do you start with it? Is there a set of circumstances where you might not get prosecuted for that? Well, yeah, probably. But it is one of those practices that looks bad, attracts attention, and then you have to defend it. You're already losing at that point. I don't advise people baking product into first pencil. The best practice, the safest practice is all we're talking about is this vehicle at the advertised price, and also explaining what is the term, a realistic term. Don't start with 24 months. Most people are doing 72 now. Realistic term, average APR until you know their actual APR at that price. It's got to be transparent. It's got to be clear. You got to learn how to sell cars by building value. Sorry.
More questions flowing through here. Vehicles on our website have different tabs for cash, finance, and lease. The dealer discount is the same on all three, but finance and lease have itemized rebates listed. Is that a violation?
Can't tell without seeing it.
Okay. On the website, I can list no haggle price. Can I list no haggle price? X. Second line, doc fee of Y. Third line with total cost,
Nope.
X plus Y.
Nope. 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 The fee is
Uh,
the advertised. Again, they're trying to roll it all into one and only one number with no math required.
what if there is an optional product disclosure statement on the customer proposal that states the optional products are not required for vehicle purchase or to obtain financing?
I would want to see any document before I passed on it. And again, I'm not giving legal advice here, but I have been involved in cases where this has been an issue. Um, it is a bigger issue today than it was a week ago. Um, Anytime on first pencil on a customer proposal that you're starting to put stuff that is going to increase the advertised price, you are now in enemy territory. You are now in a position where you are going to be playing defense. There have been University of Virginia men's basketball team won a national championship with great defense. Maybe you're that dealer. I don't want to be in that position.
Got another one for you. And I do just also want to say before we throw this question out to Jim, one of the best things that you can do right now is to review your advertising posture. You can do it yourself internally. That's great. Regulators always love a independent third party taking a look at it. Having a documented review that has went on, and if you do identify any issues, remediating those issues is probably the strongest posture that you can put yourself in if the FTC is going to continue to go after dealers for advertising malpractice. So that's one thing that you should be doing right now. Brett Westbrook asked, what about vehicles that have a national rebate and also a business center rebate that don't qualify for being titled in a state that is not in the business center?
I'm tr-
We're
Once
getting
again, I'm not
nationwide.
sure. I'm not sure I quite understand that question.
Brett, if you could add any just extra color, that would be great. And guys, we were very happy to educate and even more happy to continue this conversation. I'm gonna put. I think
There,
Chad mentioned earlier we will provide this presentation to anybody that wants it, and I am gonna drop mine and Jim's email addresses in here. You
I
can
just,
continue to reach out. Oh, there you go,
yeah,
right
I
there.
just popped mine up. If honestly, if you have any questions, you can reach me, email, office number, cell number. Um, I'm happy to help. There, there are a lot of gray areas, and a couple of the questions focused on them. And it's sort of like, can I get away with? You don't really want to be in a gray area, and we're a compliance company, so obviously we want you to be in the pure white light. But I'm happy to talk about all these. I would leave with this thought. The big takeaway, maybe there are two big takeaways from last week with the FTC's letters. Takeaway number one is your advertised price has to be what anybody can pay no matter what, other than taxes and government fees. That it all rolls back to that. And the second big takeaway is they're playing with live ammo now. This is this is serious stuff. The world is on notice how they're going to enforce going forward. And the best thing to do is roll everything into that selling price and be transparent, be clear, be honest. And by the way, you can't say no haggle price and then add something to that price. It just doesn't work. Um, and I find it interesting times because this one change in how our industry attracts customers is going, I believe, to necessarily change how we sell cars as we get away from price alone being the main determinant to attracting people to customer experience. And that is going to require people to relearn how is it we sell cars. And I think at the end of the day, it might result in a greater customer experience and even greater profitability for the dealers that do it right. Tyler, that's all I got.
For everyone asking if you can have a copy of this presentation, we will send a follow-up email with either a link to the presentation or a link to a page where you can download the presentation. We'll get that out to you, hopefully by end of business today, could be tomorrow morning. But yes, we'll get you all a copy. Jim, thank you very much. Everyone, thanks for attending. And please feel free to reach out with additional questions. We are here to help. Thank you.